I'm now calling into session the Florida Commission on Ethics for this virtual meeting via Zoom. It's December 18th, 2025 at 4:02 p.m. We are going to conduct a public session only during this Zoom. Ms. Westbury, could you please do a roll call?
Yes, Commissioner Bain. Commissioner Fuste.
Bain is here. Sorry, I was
I
on
see.
mute.
Hi.
Fuste's here as well.
Okay, Commissioner Hellman. Commissioner Lyle. Commissioner Lucas.
I'm here. Can you guys hear me?
Yes.
Sorry.
Commissioner Phillipson.
Here.
Commissioner Rogers.
Rogers here.
Commissioner Stewart.
Here.
We have a quorum present.
Thank you. Although we are in seated position, it is our tradition to do the Pledge of Allegiance at the beginning of each of our meetings. So if you will please join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. This public meeting is being streamed live on the Commission's website. Commissioners, please mute your mic unless you are speaking and keep your video on for the duration of the meeting. Also, please silence your cell phones and your office phones as notifications can be disruptive to the live feed. If you are one of the opinion requesters or an attorney with a matter on the agenda today, please mute your microphone and camera until your matter is called. Thank you. The first item on our agenda is a consideration of advisory opinion file 2825. Any public officer, candidate for public office, or public employee in Florida who is in doubt about the applicability of the disclosure laws or the standards of conduct to himself or herself, or anyone who has the power to hire or terminate another public employee, may seek an advisory opinion from the Commission about himself, herself, or that employee. Advisory opinions are based solely on the facts provided by the requester and are legally binding on the conduct at issue. Are there any members of the Commission who need to make a disclosure regarding this matter? Seeing none, is the requester in attendance? I believe Representative Fabricio. Thank you for attending today. We appreciate it. And I'm going to ask Ms. Amelia Naomi to present the draft opinion.
Thank you, Mr. Chair. So this opinion concerns the applicability of the constitutional in-office representation ban to a state representative who wishes to represent a client before the Florida Board of Bar Examiners. Now, turning to the language of the in-office representation ban, which is at issue here, Article 2, Section 8E of the Florida Constitution states in relevant part, no member of the legislature shall personally represent another person or entity for compensation during term of office before any state agency other than judicial tribunals. As such, in order to make a determination regarding this inquiry, we must address whether the Board of Bar Examiners is a state agency, and if so, whether it fits in the exemption for judicial tribunals. So the term agency, for purposes of the in-office representation ban, is defined in Section 112.312, subsection 2, Florida statutes. This provision in relevant part states that agency means any state, regional, county, local, or municipal governmental entity of this state, whether executive, judicial, or legislative. So given this definition, it appears the Board of Bar Examiners is a state agency for purposes of Article 2, Section 8E. To go into that a little bit more, Article 5, Section 15 of the Florida Constitution states that the Supreme Court shall have exclusive jurisdiction to regulate the admission of persons to the practice of law and the discipline of persons admitted. To exercise this constitutional authority, the Florida Supreme Court created the Board of Bar Examiners to evaluate candidates for admission to the bar, and it has explicitly stated that the Board of Bar Examiners is an administrative agency of the Supreme Court of Florida created by the court to implement the rules relating to bar admission. Furthermore, the Florida Supreme Court has held that the Board of Bar Examiners is a state agency under the judicial branch of the government, and its employees are state employees. So, as such, it appears the Board of Bar Examiners is a governmental entity of the state of Florida housed within the judicial branch and thereby falls under the definition of the term agency for purposes of the constitutional prohibition. So, because the Board of Bar Examiners is a state agency for purposes of Article 2, Section 8E, the question then becomes whether the Board of Bar Examiners is a judicial tribunal, as Article 2, Section 8E only prohibits state legislators from representing clients before state agencies other than judicial tribunals. Now, the definition of the term judicial tribunal is not found in the Constitution. In fact, the term judicial tribunal only appears in the Constitution once, and it is in Article 2, Section 8E. That phrase is also not defined in Part 3 of Chapter 112, Florida Statutes, which is the Code of Ethics. However, in a case called Myers versus Hawkins, the Florida Supreme Court analyzed whether the Florida Public Service Commission was a judicial tribunal for purposes of the prohibition. So in making its determination in Myers, the Florida Supreme Court created what they called a predominant characteristics test to determine whether the agency had characteristics that were judicial in nature. In applying the test, the court looked to 4 factors that the average voter would understand to encompass governmental bodies that are judicial tribunals. 1, the agency presides over proceedings that are adversary. 2, the agency is comprised of an impartial group of decision makers. 3, the agency has the power to issue final orders that it has the power to enforce. And 4, an identifiable standard of appellate review can be used to test the agency's decisional processes to ensure due process. Now, when applying the 4 factors to the Public Service Commission, the court acknowledged that some of its functions certainly satisfy those 4 factors. However, after analyzing the agency's responsibilities in the context of these 4 factors, the court also emphasized that a distinction must be made between agencies that possess the judicial characteristics for only some aspect of their activities and those possessing those characteristics for all or virtually all of their activities. Now, the court clarified that only those agencies where only all of their responsibilities, or virtually all, fit the 4 factors should be considered judicial tribunals for purposes of Article 2, Section 8E. The court noted that the functions of the Public Service Commission that satisfied the 4 factors were only a fraction of its functions, albeit highly visible one. So as a result, the court ultimately concluded that the Public Service Commission was not a judicial tribunal for purposes of Article 2, Section 8E. Now, turning to the present situation in applying the predominant characteristics test from Myers to the Board of Bar Examiners, it doesn't appear that the Board of Bar Examiners is a judicial tribunal within the contemplation of Article 2, Section 8E of the Florida Constitution. So review of the rules of the Supreme Court relating to admissions to the bar indicate that some of the Board of Bar Examiners' operations pursuant to its character and fitness determinations certainly involve activities that satisfy the 4 factors articulated in Myers, such as the hearings contemplated by Rules 3-22 and 3-23. However, a review of the rules also indicates that the hearings conducted pursuant to the Board of Bar Examiners' mission to make character and fitness determinations clearly do not constitute all or virtually all of the Board of Bar Examiners' operations. So, for instance, in applying those 4 factors to their other main function, which is administering the bar exam, the factors don't appear to be satisfied. The act of administering a licensing examination is certainly not an adversarial proceeding before an impartial group of decision makers, and scoring an exam also does not involve the issuance of enforceable final orders. And from a review of the rules, there's no identifiable standard in terms of an applicant seeking to appeal his or her examination score. So as such, under the Myers test, it does not appear that the Board of Bar Examiners is a judicial tribunal. However, if you stop the analysis there, you'd be left with a proper mechanical application of that Myers test, and yet a counterintuitive and impractical result. The result is counterintuitive because, as the Supreme Court in Myers wrote, the purpose of this ban on legislators representing clients before agencies is, quote, to prevent those who have plenary budgetary and statutory control over the affairs of public agencies from potentially influencing agency decisions or giving the appearance of having an influence when they appear before the agencies as compensated advocates for others. Yet here, there's no actual risk of that concern materializing. The Board of Bar Examiners is entirely funded upon fees assessed by bar applicants and registrants, and the legislature exercises no budgetary control over this particular state agency. Similarly, because the Board of Bar Examiners is an agency of the Florida Supreme Court and is therefore a judicial branch agency, due to the tenet of separation of powers, the legislature also has no material statutory control over the affairs of the Board of Bar Examiners. So the result dictated by just a strict application of the Myers test is impractical because the mechanical application of this predominant characteristics test here would operate to prevent Representative Fabricio from accepting an employment opportunity to represent his client before the Board of Bar Examiners. Yet that interference would not actually advance the purpose for which the prohibition was created that the court talked about. So, in instances similar to this, the Commission has applied Section 112.316 Florida statutes to negate the mechanical application of an ethical standard when there's no actual risk of harm from a breach of the public trust. Now, although Section 112.316 is only operable by its terms to negate the application of Part 3 of Chapter 112 Florida statutes, it's evident that Article 2, Section 8E in the Florida Constitution is only enforceable by the mechanisms of Part 3 of Chapter 112. So where the use of Part 3 of Chapter 112 to enforce Article 2, Section 8E of the Florida Constitution would not serve to advance the public trust in government and would only needlessly prevent an employment opportunity, we recommend you apply Section 112.316 to negate that operation of Part 3 of Chapter 112. So for these reasons, under the specific circumstances provided, Article 2, Section 8E, Florida Constitution will not prohibit Representative Fabricio from representing his client before the Florida Board of Bar Examiners. So with that, I submit this draft opinion for your consideration, and I'm happy to answer any of your questions.
Thank you, Ms. Naomi, for that thorough analysis. Do any of the commissioners have any questions for Ms. Naomi? Seeing none, Representative Fabricio, would you like to make any comments, or here's your opportunity to speak on the matter as well?
I agree with the opinion. I think there is the Myers case analyzed the 4 factors pursuant to a matter, I believe, that a Florida senator was trying to bring before the PSC. The PSC is starkly different from the Florida Board of Bar Examiners. I agree with the analysis provided by Ms. Naomi, and I appreciate the work that her and staff have put together.
Thank you. I appreciate your support for Ms. Naomi. Is there any other discussion among the members for entertaining a motion? Seeing no discussion, entertain a motion on adopting the draft opinion.
Second.
Second. Ms. Westbury, can you call the roll for the vote, please?
Commissioner Bain,
Yes.
Commissioner Fuste,
Yes.
Commissioner Lucas,
Yes.
Commissioner Phillipson,
Yes.
Commissioner Rogers,
Yes.
Commissioner Stewart.
Yes.
Motion passes.
Thank you. Thank you, Representative Fabricio, for coming today.
Thank you all.
Next is a consideration of advisory opinion file 2827. Are there any members of the commission who need to make a disclosure regarding this matter? Seeing none, is the requester in attendance?
Yes.
Ms. Wallace, thank you for joining us. And then Steve Zolkowski will be recognized to present the draft opinion.
Thank you, Mr. Chair. Commissioners, I will keep my remarks brief on this draft opinion before you right now. This request comes to us from an inquiry from Ms. Annie Kate Wallace. who was recently appointed by the governor to the Polk County School Board. Ms. Wallace, in her private capacity, is also the Director of State Government Affairs for Charter Communications. Ms. Wallace has asked us to analyze whether her continued employment at Charter violates the in-office lobbying ban, which is that new constitutional restriction found in Article 2, Section 8, F2 of the Florida Constitution. As a school board member, Ms. Wallace is a public officer subject to this particular prohibition. What the prohibition says is that certain public officers during their term of office are not able to lobby for compensation before the federal government, before any agency of the state government, or any local government entity. Ms. Wallace has supplied, as part of her inquiry, her job responsibilities in her current role or in her role at the time as Director of State Government Affairs. Ms. Wallace candidly disclosed that about 5% of her duties involve attempting to influence local government entities regarding their policies or their ordinances, specifically or mostly regarding right-of-way permitting. Now, while 5% doesn't seem like a big number, it seems like a very small percentage of a job responsibility. Under the prohibition, any amount of lobbying for compensation will trigger the prohibition unless an exemption applies. There are a few exemptions written into some of the definitions in the implementing legislation for this constitutional prohibition. One of them is found in section 112.3121, subsection 12B2. And what it provides is that employees acting in their private capacity and in their normal course of their job responsibilities, they are able to lobby unless they are principally employed for government affairs. Being principally employed for government affairs is defined also in that implementing legislation as meaning that the employee's most significant responsibility is overseeing relationships or with or contacting those government entities. This exemption will fail for Ms. Wallace. It won't be applicable for Ms. Wallace in the job that she defined for us in the director role. Even though 95% of her work is not lobbying, it involves things like equipment repair or disaster restoration, things like that. Her primary role is to be a liaison to the local governments, which is government affairs work. Therefore, we would say that she is principally employed for government affairs, so that exception will not be available to her. We distinguished in the draft opinion, we distinguished the situation before you today from one in an opinion that you heard earlier this year involving a mayor who was also asked to lobby the federal government in his private capacity for his private employer, which was a nonprofit. You'll recall was something called the John Birch Society. And this mayor, his principal duties were not government affairs. His principal duties were fundraising. Here, where the job responsibilities are primarily government relations, there's a difference between those two. The exception applied to the mayor, but won't be available here. So question 1 of this draft concludes to say that in her current role as Director of State Government Affairs, she cannot perform the lobbying duties while serving on the school board. Those duties would either need to be reassigned or a different role might need to be taken on. In question 2 of the draft, Ms. Wallace, during the course and evolution of this draft, which there was a lot of communication between Ms. Wallace and I, she sent over a second job description, one that called the Senior Manager for Government and Community. And this job responsibility, this new role, focuses on community activities, communication materials, and public image. Crucially, this new job description does not include any responsibilities that would involve influencing legislative actions or discretionary actions of local governments. It doesn't involve lobbying. The question 2 concludes by saying that because the new role involves zero lobbying, taking on this responsibility as the senior manager will not trigger the prohibition in the in-office lobbying ban. And so her pursuit of work in that role would be compliant with the in-office lobbying ban. I'm available. I submit this for your consideration. I'm available to answer any questions that you may have, and I will remind you that Ms. Wallace is also here to speak on the matter if you need.
Is there any questions of the members for Mr. Zukowski? Mr. Zukowski, thank you for that presentation.
I have a question to Ms. Wallace. So are you willing to drop the first request on the lobbying and go with the second one for your senior position that was just described by Steve? Is that where we're at on this?
Thank you, Senator. I would say that the company is wanted to first wait and see what the commission's decision was. It would either fall between me doing my current job, but just omitting the lobbying restrictions, if in fact you all agreed with the staff's opinion, which, by the way, as an aside, I'd like to very much thank and compliment your staff, and they are the embodiment of public servants, and I hope to model that in my service as a school board member, so thank you. Back to your question, we were trying to just make sure through this one exercise that as a company and as an individual seeking to abide by Florida law, adhere to ethical standards, that we knew what the options are. So to answer your question, I may stay in my current role and just omit the lobbying part per the recommendation, or I may evolve to that other role, but we just wanted to have it all vetted in one opinion.
Is there any other questions for the general counsel before we give Ms. Wallace an opportunity to speak? Seeing none. Ms. Wallace, would you like to elaborate any further? We appreciate your comments about our commission staff. They work tirelessly and often work very hard leading up to our meetings.
Yes, sir. Thank you, Commissioner. I just have a couple thoughts because I can tell you I've been in this Florida advocacy government affairs space for close to 20 years now, even though I'm only 29. I'm just kidding. But just when this situation presented itself, I just wanted to share, and this isn't to change your minds, but just to give you some context from where I'm coming from, is that when I first interviewed for this opportunity with the governor's office, I very clearly described my position. And their perception was that this lobbying ban did not apply to individuals who were not registered to lobby. And as y'all see in the materials, I'm not a registered lobbyist because I'm sure, as you're familiar, that most lobbying activity in local government in the state of Florida doesn't rise to the level of having to register unless those specific jurisdictions require it. And I just happen to not have needed to lobby, or I don't cover jurisdictions that require that. So it just hasn't risen to that level for me. So that was one thing that upon further examination, we realized that might not be the case, as was the governor's office position. Two is, and this is just an irony, and I'm saying this for the record and perhaps for various people who may be studying this case, something your staff shared with me is that I'm an early test case for these new policies, and there's new situations that are coming out of the woodwork all the time, is that this is a job I was already doing. It's very interesting to suggest that by me becoming a school board member, that it would somehow or some way aid and abet my ability to deliver things for charter communications or to enrich myself, because I was already doing the job. I think that if I could wave a magic wand, I would say that what would make sense is to not lobby in Polk County, because I do wear that public official hat, and to not lobby the state. That would be a much narrower exemption. I'm struggling with how me being a school board member would interfere or aid and abet in my ability in talking about an ordinance with a city or county government nowhere near Polk County. Our industry, when I say our, I mean charter communications and the internet service provider industry, phone industry, cable industry, we in no way answer to school boards. They don't regulate us. We do business with them, but so do all kinds of other businesses and industries that school board members themselves work for. And I'll close by saying I thought that was interesting, that opinion 25-3 that y'all did for the new mayor of Newberry. And he was vetting whether he could lobby, right? But what's interesting is, and I know there's no law speaking to this, but what I found interesting is that a lot of public officials at the local government level work for nonprofits, may or may not fundraise for them, and then may or may not have contracts with the very governments they serve on or with other local governments in their communities. I have colleagues on the Polk County School Board who work for nonprofits that have contracts with Polk County Public Schools, that have contracts with local government within Polk County. And yet all the state of Florida asks them to do is to not, or to abstain themselves from votes related to their organizations, which is what I would do if we were voting on an internet service provider contract at the district, right? But I do find it interesting that upon further examination of the statute, that by me volunteering to serve my community of Polk County in education, that it is interfering with my ability to make a living doing, having conversations with completely different jurisdictions, with completely different purviews, that I think a lot of people would have to do mental gymnastics to assume that I would somehow be aiding and abetting. I will close by saying, again, I see how and why the staff arrived to their opinion. Charter, I don't speak for Charter directly, but I will say that the reason I'm sitting here today is because as a company and myself, we are both committed to being completely ethical and following Florida law. And we're here out of an abundance of caution and not because of what we were told to do in passing. So thank you. And again, if y'all have any questions, I just wanted to just mention that this just feels like it doesn't make sense in a way. I wish it could be a little narrower, and I wish jurisdiction and oversight of what government I serve on versus what governments I appeal to were under consideration under Florida law.
Thank you, Ms. Wallace. Is there any other questions of the members? Any further questions any member wants to ask at this time?
Yeah, Mr. Chair, question.
Sure, Commissioner Rogers.
Yeah, thank you. Mr. Zakowski, so first of all, great breakdown of this. We talked about this a little bit in prep for this. To Ms. Wallace's point, first of all, I think I agree with her largely on, there's zero chance for a conflict in many other situations she's bringing up. I'd ask you, though, I think we may even agree with her, subjectively, but I think your stance would be the law doesn't make that, the law is written right now does that not make that distinction and does not leave room for that distinction. Would you concur with that statement? Am I reading staff correctly on that?
I think there's a couple of things going on there, Commissioner, through the chair. What I would say is we don't really get to make the policy choice here about where this law, what the law does or doesn't say, right? That, what we do get to do is apply it. The position outlined in this draft is consistent with our litigation position in the federal court case right now, which is important for you to know. I will say some of the other things that were brought up about the other board members who might serve on nonprofit boards that are potentially doing business with the agency, that sort of thing
Or employed by the nonprofit, just to be clear.
Oh, yeah, employed by the nonprofit. There are some exceptions to a different standard. That's the conflicting contractual relationships standard, 112.313 subsection 7A. They're baked into the statute are a bunch of exceptions. Without knowing anything about those individuals, I wouldn't be able to opine on that. But that conversation is a different standard than what we're opining on today. So to answer your question, I think the policy choice here has been made. The voters voted for this particular amendment to put it in. This is a very conservative view of applying that policy without ignoring it. So that if you have another question about that or a more particular question, I'd be happy to answer that.
Yeah, Mr. Chair.
Yes.
I thank Mr. Zakowski. I just want to clarify. I think our understanding and staff's interpretation of the amendment and hence the state constitution is, and that's, it's a school board member who is employed for a telecom provider, even though there may be and there is no association with it, right? In this case, and going to other counties, cities, federal, as written and as adopted, we don't see room for that for that different, right? It doesn't say in relation to the area where you have control and jurisdiction. Because I think in intent, I agree with Ms. Wallace, but by writing, I think I agree with what staff has written up.
It doesn't make a distinction between close to home lobbying and lobbying more remotely from your political subdivision. It's the ban is pretty clear in that way. It's all federal government agencies, all state agencies, all local agencies and political subdivisions of the state.
Thank you. Any other commissioners have any other statements they would like to make? I appreciate it. And I appreciate Mr. Zolkowski's going through this. As we know, we have ongoing litigation in this matter. It's our role as a commission is limited to the laws as they're written because of our capacity. We are just to apply the law to the facts, and we've been provided the facts, and we provided the law as it is written today. So with that, I will entertain a motion on the adoption of the draft opinion. Is there a motion?
So moved.
Is there a second?
Second.
Ms. Westbury, can you please call the roll?
Commissioner Bain,
Yes.
Commissioner Fuste,
Yes.
Commissioner Lucas,
Yes.
Commissioner Phillipson,
Yes.
Commissioner Rogers,
Yes.
Commissioner Stewart,
Commissioner Stewart?
You're muted.
Sorry, yes.
Okay, thank you. Motion passes.
Thank you. Thank you, Ms. Wallace, for joining us today, and thank you for your service to the people of Polk County.
Thank you all for your service to the state of Florida. And I regret the circumstances, but I now ever more appreciate the work you all do and the purpose you fulfill. So thank you.
Thank you. Moving on to our agenda, the last item on our agenda is the rule review required by section 120.5435 for fiscal year 25-26. Just to reiterate, this is not us adopting new rules. We aren't doing any rulemaking at this meeting. This is purely to, per that provision, provide information about what rules we're reviewing. Before doing that, the moderator, do we have anyone any public members in the waiting room?
There appears to be one, and it's the Florida channel. So,
okay. I don't think they're making any comments, so we can proceed. I am going to recognize Miss Naomi. First, item 4 of the agenda relates to recent changes made to the Administrative Procedure Act, Chapter 120 of the Florida statutes. Again, as I stated, the Commission is not engaging in any rulemaking today. The matter before us is the consideration of the intended agency for the Commission's rule review that is required under Chapter 120. Ms. Naomi, can you go over the information in our rule review packet that was provided?
Thank you, Mr. Chair. So, as the chair just mentioned, in the last legislative session, changes were made to the Administrative Procedure Act in Chapter 120. These changes require state agencies to review each of their rules over a 5-year period, accounting for various statutory factors to ensure the rules are up to date, in the proper form, have statutory authority, and are consistent with the legislative intent of the laws they implement. So the requirements regarding the rule review are found in section 120.5435. This section also provides a very specific timeline for how agencies should conduct this rule review each year. So the first step in the process is that by January 1, each agency must submit a report to the President of the Senate, the Speaker of the House, and the Joint Administrative Procedures Committee, which we refer to as JAPC, summarizing its intended action on each rule being reviewed for that year. For each rule, the agency can either make no change to the rule, make a technical change to the rule, make a substantive change to the rule, or repeal the rule. The statute only requires that this initial report contain a summary of the agency's intended actions, not the exact language that it wants to use later on in the process. So a draft of this initial report is what is in front of you all today. Now, currently, the Commission on Ethics has 188 rules organized under various rule chapters in the Florida Administrative Code. Each of these rules will have to be reviewed within the next 5 years, with at least 20% of the rules being reviewed per year. So this year, the staff reviewed chapters 34-5 and 34-17, which is 44 rules total, using the factors that are laid out in section 120.5435. And we've prepared the required summary for your review. For each rule under review, the summary just indicates either that no change is needed or what technical or substantive changes are recommended. Nearly all of the recommendations are minor in nature and simply update the rules to reflect current legal citations and commission practices. So the summary recommends the following: updating legal references, including statutory and constitutional citations, and removing references to any rules that have been repealed. Removing language in the rules which extensively just quotes and repeats the ethics statutes, which are duplicative. Changing reference to a party to a respondent for the sake of clarity, given that respondents are the only parties to our cases. Removing language in one of the rules allowing commission investigators to report evidence of wrongful acts to the commission, which appears to lack statutory authority and has actually never been used before. Updating the options for the commission when a referral is being recommended as legally insufficient to reflect the current statutes and practices. And then removing language that states that complaint proceedings against separate respondents can be consolidated, given that this raises concerns with our confidentiality statutes and does not reflect current practice. And then just renumbering subsections when needed. So I ask you to authorize us to submit the attached summary along with a cover memo to the Senate President, the House Speaker, and JAPC as is required by the statute. Again, as the chair pointed out, this is not a rulemaking hearing. It's simply the initial step in the rule review process. You'll only be authorizing us to submit this initial summary, thereby notifying these officers and agencies of the changes that likely will be needed. Next year, we'll propose actual updates to these rules, reflecting the recommendations in the summary with specific coded language you guys can see. And at that time, you'll be asked to approve those specific updates for the rules in question. So with that, I submit this summary for your review, and I'm happy to answer any questions.
Thank you, Ms. Naomi. Are there any questions, or is there a motion to approve the summary of intended agency action as outlined by Ms. Naomi?
I have one question for Ms.
Yes,
Naomi.
Commissioner Stewart.
Yes. So when you submit this report, do they look at it and send comments back to you as to whether they think that you've done the right approval or that you've done the right changes? Do they review it or they just accept it?
Yeah, so that's a great question. Through the chair, there's nothing inherent in the statute that says that they're 100% gonna send us feedback on anything. I imagine if there was something that concerned them or anything like that, they might. But it's not until the next step of the rule review process, which is the coded language we have to submit by April 1, where we have to get, for example, for technical changes or no changes, we have to get JAPC to certify that. But this initial thing, there's nothing in the statute that, says they're 100% gonna give us feedback.
Any other questions of the members?
Yes, Mr. Chair.
Commissioner Rogers?
Yeah, thank you. First, Ms. Naomi, I want to say excellent analysis on the opinion, the first one we looked at in respect to Rep. Fabricio. You really dove in well there. On the rule review, I want to confirm that the only guidance that we get and that agencies get for looking at rules are those 7 kind of guidance policies from 120.5435. I'm a little surprised. I know, like, when I worked for government, there was a general consensus of remove bureaucracy and rules. And I'm surprised. I just want to make sure that didn't come through as part of that statute, and I don't see it as one of those 7 or an 8th tenant. I just want to make sure there's no other statutory guidance or even just maybe accessory language that might not have been called out in the 7 to that effect. I mean, I think they're good tenants to apply, but I don't see anything towards like the minimalizing or simplifying rules.
Through the chair, that's a good question. So yeah, those are the 7 factors that are laid out in the statute. But one thing I wanted to point out is this rule review process is separate from just the general rulemaking process. What we're doing right now doesn't preclude us from, if we wanted to make a change to one of our rules after we already reviewed it, we can certainly do that as well, or just completely separate and apart from this, we can still engage in regular rulemaking. So if there's any sort of changes that you guys see that, isn't really addressed by any of these factors, but you wanted to, engage in rulemaking on something, this rule review process doesn't preclude you from also engaging in just the regular rulemaking process.
Any other members would like to make a statement or ask a question? Seeing none, Commissioner Stewart, did you have? Okay. Seeing none, is anyone willing to make a motion to approve the summary of intended agency action as outlined by Ms. Naomi?
I'll approve it. I move for the approval of the over.
Second.
Second. Ms. Westbury, can you please call the roll?
Commissioner Bain,
Yes.
Commissioner Fuste,
Yes.
Commissioner Lucas,
Yes.
Commissioner Phillipson,
Yes.
Commissioner Rogers,
Yes.
Commissioner Stewart. Motion passes.
Thank you. And thank you, commissioners, for making time this afternoon, and the staff for arranging everything for us to have this session so we could address those 4 topics. Wish everybody a happy holidays and a healthy new year. Looking forward to seeing all of you in person in January, and we'll entertain a motion to adjourn.
If I can just real quick, through the chair,
Yes.
I just want to mention, like I've done before, it's just incredible the amount of work the staff does over there. I want to echo the gentleman who spoke earlier. I mean, just going through the stuff and the density and I was going to ask for a Venn diagram. Amelia, for the first one, I was going to ask you for a Venn diagram because I get lost in this. Just wanted to say it's excellent work, and again, the entire staff. I can't say enough. Thank you.
Thank you. Second.
Well, we all appreciate the staff and everything they're doing. Hopefully they'll have a restful break over the holidays to recharge for 2026. And is there a motion to adjourn?
So moved, Mr. Chair.
Second?
Second.
All in favor, say aye.
Aye.
Aye. Thank you. We are adjourned, and happy holidays, everyone.
Happy holidays. Thank you. Good to see everyone.